Welcome to The Ethical Advocate for Accidents.
Welcome to The Ethical Advocate for Accidents with Attorney James Sadigh. For more than 35 years, James has helped injured Californians navigate personal injury claims, insurance disputes, habitability issues, and wrongful termination matters, always with a focus on ethics and clear, honest communication. I'm Leanne Lyon, and today we are joined by criminal defense attorney Jasmin Haghani to discuss how criminal charges in California can either strengthen or complicate a related personal injury case. When an accident leads to criminal charges, how often do those proceedings influence the injury claim that follows?
I would say that they're very relatable. Obviously, they arise from the same incident. And so we have different situations where it comes to witnesses, statements that are made, and of course, the Fifth Amendment right to remain silent. And so I would say that, cases that have a criminal component usually it's better to try to resolve the criminal portion of it, before getting into the civil portion of it. However, we can't always control it. Usually they do kind of end up starting at the same time. Obviously, criminals a little faster. But I would say that, two attorneys that are working on the same case, civil and criminal, would probably really benefit from timing things together and even perhaps even asking for some court intervention with proceedings being stayed and other measurements that can be taken while protecting the individual in a criminal proceeding and then, going back to the civil case.
As far as the civil recovery, it definitely affects it, whether you're at fault or you are not at fault. If the defendant is at fault in the civil proceeding, the civil attorney can usually ask for extra damages rather than just a regular out of pocket damage, damage to the vehicle, medical bills and pain and suffering. They can ask for punitive damages, which, if it comes as a verdict, it cannot even be discharged in a bankruptcy, and he has to pay no matter what. And if the person who is not at fault ends up being a criminal in the accident, let's say he was a drunk driver, uh, it always psychologically comes back and affect the trier of the fact, whether it's a jury or a judge, to decide that, yeah, he was a victim of this accident, he wasn't at fault at the accident, but he really is not a nice guy. He was drunk at the time of the accident, or he was doing something crazy that is criminal. Psychologically, it will affect the type of restitution that under the civil case will come to him, because people don't like criminals. Simple as that.
So, Jasmine, if somebody enters a guilty plea in a criminal case, can that admission later be used as a personal injury lawsuit?
Yes, it can be used against you. We have actually, we have more than one standard when it comes to law. So, in a civil injury case, personal injury case, the standard of proof is preponderance of the evidence. While in criminal courts, it's beyond a reasonable doubt. So, if you have a conviction in a criminal proceeding, and that standard is so high, then, obviously it could affect you in a civil proceeding. However, if it was the other way around, someone may be held liable or found liable in a civil matter, because the standard of proof is lower than a criminal case. But once it comes to a criminal case, maybe they aren't guilty because the standard of proof is much, much higher. So I would say that it does.
There is a caveat, however. You got to look at what was the criminal charge in comparison to what caused the accident. Because in an accident, someone may be criminally charged with being drunk or not having insurance. Uh, but the cause of accident may be that the other person ran the stop sign. So a criminal conviction has to be related to the cause of the accident. Of course, drunk driving most often is used against the defendant for the fault. But if the criminal charge that is preceding an accident is that he didn't have the proper driver license or he didn't have insurance, that does not affect whatsoever the degree of fault in the accident, even if he's convicted in the criminal case.
James, does a conviction make it easier to establish fault in an injury case, or does the injured person still have to build the case independently?
Depends what the criminal conviction is all about. Um, the criminal conviction, if the criminal conviction is that the person ran the stop sign and that's the cause of the accident, well, of course, if he goes to a traffic court and he found to be guilty for running the stop sign or running a red light, or in a rear end accident, if the police has charged the defendant as following too close in violation of the vehicle code and actually want to prosecute it through the court, uh, even though it's an infraction, absolutely, because the finding of the criminal court, whether it's a traffic court or misdemeanor felony court, is beyond a reasonable doubt. Whether the person pleads guilty or is found to be guilty, doesn't matter. It's beyond a reasonable doubt. So that will make it easier for me if I'm representing the injured driver to say, I don't need in the civil court to go and prove with preponderance of evidence that this person ran the stop sign or ran the red light, because already it was proven in a criminal court beyond a reasonable doubt, which is a hell of a lot heavier burden than the preponderance of evidence. So the only thing will remain when I go to court, I'm going to tell the judge, make a ruling that the other party is found to legally be at fault in this situation. I've committed this negligence under the law. And the only thing I have to prove to the jury and the court is the amount of damages. So that makes it easy. And of course, the insurance companies that represent the person at fault in that situation know it very well that if there is a finding of the fact in the criminal court that the person has violated the law and is found guilty, is going to be so that it's much easier to get good money out of them for settlement. They don't want to go to court.
For sure. Jasmin, how does the Fifth Amendment come into play when someone is facing criminal charges and a damages claim at the same time?
So I would say, in a criminal proceeding, you absolutely have a right to the Fifth Amendment, and a jury can't infer that you're guilty because you're invoking your Fifth Amendment right. Now, I'm sure James will touch on that, how that can come into play in a civil proceeding, whether somebody does testify or doesn't testify. But for a criminal defendant, the fact that they didn't testify doesn't mean that they're guilty.
In the civil case, it does affect. I've had actually one occasion where, for whatever reason, the criminal proceeding was not going fast enough. So even though it was almost 2-3 years after the accident, the criminal proceeding, with the stipulation of the defense attorney and the prosecutor, was still going on. Well, the statute of limitation had come up, and we had to file a lawsuit, and we were proceeding, and for some reason, the trial judge in the civil court did not stay the action. And so they were pushing to take testimony of my client. And of course, my client, under my advice and the criminal defense advice, was taking a Fifth Amendment right and not answering how the accident happened. Where was he going to? Where was he coming from? What was he doing? And this did not have a very good look in front of the jury later on, even though he was absolved later on in the criminal court. When we went back to the civil court, it did not look good for the jury that when they were asking questions from him before, he was saying, I'm taking my Fifth Amendment right and not answer. And now he's sitting in a trial and actually saying what happened to him. So, again, psychologically, it makes a difference. Any criminal conviction has a minimum a psychological effect on the recovery of the man.
Are there situations where resolving the criminal matter quickly can actually move settlement discussions forward?
Yes, it's, we've had situations that the person who had caused the accident was later on was found to be, well, let me explain it better. The person who had caused the accident actually had left the scene of the accident, so he was charged with hit and run. So when it came for us to make a decision about the civil recovery, it was extremely easy to pick up the phone to his lawyer, to the person who had caused the accident and was a target of hit and run in a criminal proceeding, and tell his attorney, if you convince your client and or his insurance company to pay my client's total damages, we will not object for you to go and do a civil compromise in a criminal case so your client doesn't end up in a criminal proceeding and charges and conviction. So it was all dependent on that attorney to able to go to his clients, the insurance company, convince them to tender the entire policy limit, which wasn't a big policy limit. I think it was only $30,000 at the time, and say, we have $30,000 to pay for all the damages and injuries and everything that is caused in here. And at that situation, district attorney contacted us and say, do you take the $30,000 and promise not to go after them civilly, and that way it would be a civil compromise for us too? And we said, yeah, sure. So within a month and a half, 2 months after the accident, we had a $30,000 settlement for my client, which later on came up to be too much money for the damages he had suffered.
As we wrap up here, I'd love to hear from both of you on this question. When two attorneys are working together, as you have, on different aspects of the same incident, what does responsible coordination look like to prevent one proceeding from undermining the other?
Jasmin, I want to give you the floor here.
Yeah, sure. I would say, really just being on the same page about what we will allow the client to do or not to do. Certain statements, a lot of times people think that they could be helping their case by speaking onto certain situations or subjects or anything that comes into play. Anytime we make a statement, it can affect us, whether it be criminally or civilly. Anytime a statement is made, and let's say we have inconsistent statements, for example, to the insurance company or to the police, all of that can creep back up on a client. And I would say that it's very important that the criminal and civil attorney are in contact. And again, we're going in the same direction.
I want to add something here. This is one of those situations that it's best when we say less is more. A lot of people think that because there is a charge against them criminally, and or if they're a victim of a accident, whether at fault party or not, if they just explain what they were doing or why this happened, people will let them go. Well, that's not how our system is. The best thing is, and I've done it few times, I actually bring the client in. I go on a YouTube and I bring an old episode of series that most people have forgotten with Raymond Burr. And he was an attorney, not Ironside before that. And you would see, I would bring an episode that most often when the client wants to open his mouth and say something, he would hit the client and say, shut up. And he always was able to win the cases for his client. And I have to show that to them to say, let the professionals do the work. Let your criminal defense attorney and I work together and formulate the narrative for your case. We don't want you to talk. If we feel that you talking will help you, we will provide the opportunity for you. Other than that, don't push it, because the legal system is not what you think. As you may have heard in the movies, when somebody is arrested, they have given the admonitions. Whatever you say will and shall be used against you. They never say whatever you say shall be used for your benefit. So it's very important to make sure that the narrative is in the hand of the attorneys with each other's cooperation.
So I think you may have been talking about Perry Mason.
You're right. It was Perry Mason.
Yeah. So, so one final question: if a person is looking at maybe some civil as well as criminal charges, and their attorney hasn't brought up coordination, is that something, listening to this podcast, that maybe they should talk to their attorneys about?
Absolutely. Uh, in my opinion, in some cases, if it's not borderline malpractice, it would be malpractice if his civil attorney does not coordinate, or at least does not confer with a criminal defense attorney in those situations, uh, because it will affect the life and liberty and the future of a person. Again, even though I'm in the business of the civil and personal injury and recovering money for my clients, that's the way I do. But I still ethically am obligated that as a human being, the life, liberty, and the future life of a client is more important than the money. So if anything is going to affect that, I better get a specialized attorney who knows more than I about criminal proceeding and future involved to do the right thing for the client.
Well, I certainly appreciate your heart for that. So that is it for today's episode of The Ethical Advocate for Accidents. Huge thanks to Jasmin Haghani for joining us today. And if you'd like to learn more about Attorney James Sadigh and how he approaches complex injury cases in California, visit jamesksadigh.com. Thanks for listening, and remember to leave a review, and share this episode with someone who may need it. Thank you, James, and thank you, Jasmin.
Thank
Thank
you.
you, Jasmin,
It's
for
great
joining
being
us.
here. Yeah, thank you, James.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.